Hello everyone, Maria Premushko, MVP Law Group from the beautiful city of Encino. Well, today I want to talk to you about the most frequently asked question, at least from my clients and possible clients. It's what's the difference between will and trust and what are the planning options? Well, of course, let's talk about it. Historically, the first thing that comes to mind when we're talking about estate planning options is that, well, I need a will. We all read classical novels, we all watched movies, and everywhere person is writing a will on a napkin somewhere at the bar. Well, the bad news is that if there is a will, there is going to be a probate. We talk about probate all the time. Probate court is part of the legal system, court's judicial system that administers estates if there are no documents executed. So if you write a will and you still have a estate here in California, more than $150,000, there's going to be a probate administration, because the only person who can transfer title from his or her name is the person, the owner of the asset, him or herself, or probate judge. That is why if you create a will, write it on a napkin, or print it out and pay money for it, it doesn't matter. Your estate will still go to probate court. Your children or other beneficiaries will spend months and sometimes years in probate, and will spend 25 to 35% out of the whole assets to all kinds of fees. For example, me as an attorney, we make pretty good money helping clients with probate matters. However, me personally, I would rather have you being proactive and create a living trust instead, where you create a separate document and you put all the answers in: who, on what terms, when gets what. Basically, you're the boss. You do not need the probate judge. You're the boss yourself. You can create the agreement now and say that, hey, I'm in charge. When I pass, or if I become incapacitated, I appoint this person to administer the estate. I give my estate in portions or the total thing to this particular beneficiaries who you name. Because when there is probate process, anybody can jump in and say, hey, I have the right to a certain percentage or to a certain share of the deceased person's estate. When there is a trust, it is very hard to litigate. It is very hard to contest, because person will have to open a probate case. So what is another option? Of course, there's also option do nothing, no plan at all. In that case, it goes back to probate court, and judge will decide the whole thing. Whereas when you have a will, that will basically gives judge an idea what you wanted, how you wanted your estate to be administered. So it is your choice. It is very basic. Will, there is probate, no planning, probate. So it is your decision how you want to dispose of everything that you worked so hard for your life. Do you want to be in charge, or do you want probate court judge who is very busy and care less about your family be in charge? So it is your call. If you need me, call me 818-788-7881, and I'll be happy to help. Thank you. Bye.